Good evening, everyone.
Good evening.
So today we are going to do family law. As per the syllabus is very vast and it is a bit confusing also. I'll try my best that I'll able to cover everything with like clear clarification about the differences, especially because questions are asked from this unit. Like this is one of the important unit for law. So first of all, when we are talking about family law, we will be discussing Hindu law, Muslim law, and in detail Hindu and Muslim law. Other than that, we will be discussing about what is Special Marriage Act and what about Parsi and Jews marriage, Christian marriage, just a little bit. Other than that, we'll be discussing Hindu Marriage Act 1955 and the Muslim law also. So first, we'll start with Hindu law. So as you have heard about Mitakshara and Dayabhaga. These are two schools. So we are discussing where this family law and Hindu personal law is coming from. So basically, there are two schools. One is Mitakshara school and one is Dayabhaga school. Uh, Mitakshara school is the more common one, which is basically applicable all over India, except few states like Bengal and Assam. While in the case of Dayabhaga, it is applicable in these states where Mitakshara does not apply. And what is the difference between two? In the case of Mitakshara school, the important part is that father has a restricted right of alienation of joint family property. While in the case of Dayabhaga, that is not the case, and father has unrestricted right. So this means that in the case of Dayabhaga, son has no interest in property of father by just the reason of birth. So only if you are born, that does not mean that you have a right over the property. While in the case of Mitakshara, you get the right over the property just by the birth that you have taken place. So by the reason of birth, the son will become a shareholder in the property in the case of Mitakshara, while that is not the case in the case of Dayabhaga. All right. Apart from that, there are few ancient sources for Hindu law. One is like Shruti, Smriti. Do you know what is Shruti and Smriti?
Shruti is basically the uh, knowledge that had been transferred, like जो लोगों ने सुना है और
Hmm.
उसको लिखा है वो है श्रुति. स्मृति is basically remembrance.
Yes, right. So under Shruti, what comes is the Rig Ved, Sham Ved, Yajur Ved, Athar Ved. These are in Shruti. And under Smriti, it is basically what people remembered. And in Smriti, what comes is Dharm Shastra and Dharm Sutras. This is Smriti. Apart from these two, other sources are like digests and commentaries, then customs. These are the ancient sources. Apart from this, there are certain modern sources also, like justice, equity, and good consciousness and legislations and precedent. These are the modern sources. So this is about the sources under Hindu law. Now we'll just discuss quickly about Muslim law sources. Under Islam, there are some important parts. For example, Quran. This is the first important source of Islamic law. Apart from Quran, there is Sunnah. There is there are certain secondary sources like Ijma, Qiyas. Other than this, there are customs here also, and the modern sources will be here also under Muslim law, like equity, justice, and good conscience. All right. So here, when we talk about Quran, Quran is nothing but the direct words of the Prophet Muhammad. What is Sunnah? It is the trodden path. So it is basically the way of life. Isma, what is Isma? It is the consensual opinion. Opinion, it is basically the harmonious decision on a particular question which is taken up by the jurist and the companion of the prophet and the people who are learned in their religious beliefs. So according to them, they take certain opinion, they give some opinion about something, and that is known as Isma, which is known as the secondary source of Muslim law. Apart from that, there are qiyas. So what is qiyas? Qiyas is the interpretation. Okay. So these are the sources. Apart from this, most of the customs which were there as a source, they have been by abolished by Shariat. Clear? So these are the sources for Muslims. Apart from this, there is a Special Marriage Act 1954. This is made for the interreligion marriage, which can be done without conversion under Special Marriage Act. And under special marriage, it is a contract. The marriage is a contract. So when both the parties are of different religion, then they can marry under Special Marriage Act. Apart from this, there are Parsi marriage. It is also a contract. There is a Ashirwad prayer, and there is a requirement of 2 witnesses. In the case of Muslim marriage, it is a civil contract, and polygamy is also allowed up to 4 wives. And it is different for Shia and Sunni. Now let's start with the Hindu Marriage Act. Apart from Hindu Marriage Act, there is a Hindu Succession Act, Hindu Minority and Guardianship Act, Hindu Adoption and Maintenance Act. All right. So first of all, we are doing the Marriage Act. Under Marriage Act, under Section 1, Clause 2, it is talking about the territorial application. 。 So it is applicable on whole India, outside India, on Hindu. All right. So this is the territorial application. Now, under section 2, it deals with the people who are considered under Hindu. So who are the person? Here it is mentioned that Lingayat, Brahma, Arya Samaj, these are included. Then Buddh, Jain, Sikh, these are also included. And it is mentioned that any person who is not a Jew, Muslim, Christian, Parsi are included. It also includes any person who is converted or reconverted into Hindu, Buddh, Jain, and Sikh. These are included under section 2. Children, it includes both legitimate and illegitimate child if both parents are Hindu, Sikh, Jain, or Buddha. So if both parents are Hindu, Sikh, Jain, Buddha, then the children will be Hindu also. And what happens if one of the parent is Hindu? Then in that case, this is from PYQ, if any one parent is Hindu, Buddha, etc., then if the child has been brought up as Hindu, Sikh, Buddha, Jain, then he will be considered as Hindu. So if both parents are Hindu, then child will automatically will be Hindu. If one of the parent is Hindu, then it depends on the how the child has been brought up. One more section which is important as per PYQ is section 4. So here section 4 talks about the overriding effect, but like this act will have an overriding effect on all the customs, everything that happened before the act came, but there are certain saving, and the saving clause is given under 29, which says that the customs as per which, for example, if there was a marriage which was made which, by any custom which was not as per the act, but it will not be overridden. Means if there was a marriage which took place earlier, that does not mean, if it is not in line with the Hindu Marriage Act, that does not mean that those marriages are void, because it is given under saving clause. Similarly, the dissolution of marriage also, on that, it will, the overriding effect will not be applied. So these things are mentioned under section 4 and 29. Apart from this, who is Hindu and who is not Hindu, for that there was a famous case, Chandrasekhar versus Pulanavelu, 1963. So it talks about who is Hindu. So here there were certain conditions mentioned by the judge in the judgment, that if you practice, profess, or follow any of the religion like Buddha, Jain, Sikh, or Hindu, and if it remains a Hindu, even if it does not practice, profess, or follow, remains tenant of any of these religion. So this is this case. Apart from this, there are various definitions given under section 3, which is important. Generally, definition clause is under 2, but here it is under 3, section 3, definition clause. So the definition which are important here are: so these are the definition. Anyone knows about them? Any idea?
No.
Anyone else? Have you read this in PYQ? Okay. So custom and uses given under the clause A. So any custom and uses is basically what? It is continuous. It must be continuous. It must be uniform, and it must be coming from a long time. These are the three conditions to follow any to consider it as a custom, first of all. So what are the three things for customs? It must be, you can just remember a code, CUL, which is custom, must be continuous, uniform, and long time. These are the three conditions. And it must be certain, it must not be unreasonable, and it must not be against public policy. These are the conditions for a valid custom. Then, when we talk about uterine blood, it is given under clause D. What is it? When in the ancestor there's a common mother, there are two siblings and the mother is same. If they are from the same mother, then it is uterine blood. And if in the case of full and half blood, full blood means same father and same mother. Half blood means when the father is same but mothers are different. That is half blood. Then Sapinda relation. When we talk about Sapinda, as per Hindu law, it's up to 3 generation from mother side and 5 generation from father side. So these the relations which comes under these generation will be considered as Sapinda relationship, which is not valid. So the any marriage done within the Sapinda relationship is not valid marriage. We will discuss that when we'll discuss the validity of marriage and the condition given over there. But Sapinda relationship is 3 generations from mother, 5 generations from father, and it has been changed through an amendment because earlier, where it is written 3, earlier it was 5. All right, this has been removed. And earlier, where it is written 5, earlier it was 7, it has been also removed. You have to remember this also once this question was asked. And this Sapinda relationship is based on the principle of exogamy. All right. So these are the definition. Prohibited degree also, it is given under G. So there are certain relationships within which the marriage are prohibited. And what are they? Under Hindus, its first is brother and sister. Second is uncle and niece. Third is aunt and nephew. Fourth is this is brother and sister. So brother, 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 sister, 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 their children, they cannot marry. So these are the prohibited relationship, and both Sapinda and prohibited relationship both can marry if the custom allow that. So as per customary law, if there is something which is against these two principles, then it can happen. That is an exceptional case. All right. So these are the things mentioned over there. Apart from this, next is Hindu Marriage Act, Section 5. Under Section 5 of Hindu Marriage Act, there are 5 conditions for Hindu marriage given. Section 5, 5 conditions. First is monogamy. Second is consent. Third is age. Fourth is sapinda. Fifth is prohibited degree. All right. So if uh, multiple marriage, like if there is one spouse alive and you marry someone else, then those marriages are void as per Hindu Marriage Act. Then if we are talking about consent, the marriage are voidable. So the consent has to be given. It should be free consent also. Then age. For women, it's 21. For men is 18. Here, one thing that you must remember is when we
Women
talk,
till 18. है.
huh?
एज वुमेन के लिए 80
हाँ,
या
sorry,
21।
yes. So here, one thing which is important is the marriage which is done. If you are marrying if you are a male and if you are marrying at 18, it does not mean that the marriage is void. All right. The marriage is still considered valid. Only thing is, it is punishable offense. It is punishable under section 18A. All right. Which provides for 2 years of imprisonment and 1 lakh of fine or both. So it's not, the marriage is not void for the condition of age. That is important. Then Sapinda and prohibited degree. Uh, for these two cases, F and G definition, 3G and 3F talks about Sapinda and prohibited. Apart from this, when this is also not valid. Apart from this, when we are talking about these 5 conditions of marriage, which marriage is void and which marriage is voidable, that is given under section 11 and 12 of Hindu Marriage Act. Okay, under 11, the list of void marriage is given, and section 12, voidable marriage is given. Under 12, consent is given, and under 11, from the condition 1, 4 and 5 is given. Okay, 1 is monogamy, 4 is sapinda, and 5 is prohibited. And for age, as I said, it is valid marriage. So clear? So these 5 conditions, and which are valid and which are void, we have covered. This is void. This is also void. Clear? This is also punishable. Any idea? Monogamy, where it is punishable. Bigamy, where it is punishable.
IPC.
Yes. Which section? Four 94 and 95. Okay. So now, under section 7, the ceremony which are essential for marriage. It is the provision about that. And here it is mentioned, for example, Saptapati, Sanskar. If these are the ceremony, these are essential for marriage. Like recently, there was a judgment in which it was mentioned that if you are getting married under Hindu law, you have to perform the ceremonies. It's a compulsion. Then section 8, it talks about the registration of marriage. So sometimes in match the following question, these sections are asked: 5, 7, 8, 11, 12. Clear? So these sections we have done, completed. Any doubt in this?
No, ma'am.
Okay. For this ceremony, there is a case which you can remember: Ravinder Kaur versus Kamal Kanta, 1973. Now, when we talk about the end of marriage, because we have discussed the dissolution of marriage. there are two things which are different, right? There is a dissolution. So what we did here, 11 and 12, these are dissolution of marriage. There is a end of marriage also. How? By divorce or judicial separation. Judicial separation given under section 10. So if you know that it is a step towards divorce, before divorce, there is a judicial separation that happens. Um, for monogamy, there are few cases which you can remember. Priya Bala versus Suresh. Next important part under Hindu Marriage Act is section 9 and section 10. 9 talks about the restitution of conjugal rights. 10 talks about judicial separation. Do you know what is restitution of conjugal rights?
Yes, ma'am.
What is it?
तो मैम जब भी मतलब हिंदी में बताऊं,
हाँ,
रेस्टिट्यूशन ऑफ कंज्यूगल राइट्स में ये होता है कि जो वापस से कोहैबिट करने लग जाते हैं हस्बैंड वाइफ एक टाइम सेपरेट होने के बाद, देयर आर एफर्ट्स टू मेक द मैरिज वर्क अगेन, तो उस कारण से कोर्ट ऑफ वो करती है उनको कि
Ma'am,
आप
if a
वापस
person is not fulfilling his or her marital obligation, then we can ask the court to make that person follow his marital obligation.
okay. So it is basically the re-establishment of marital relation. So they have to fulfill the marital obligation, right? Correct. So the purpose, what is the purpose of restitution of conjugal right? The purpose is to sustain the marital relationship. All right. It has this concept has originated from Jewish law, and it can be claimed whenever there is a withdrawal from the society of other without any reasonable cause. The person has not given any reasonable cause and they have withdrawn themselves. So in that case, the court can interfere for the restitution of conjugal rights. So here there are few case laws through which there is a like whole interpretation of this conjugal right, and there have been question on this existence of this right only, because there are various situations where females, like for example, there was a case law where the female was required to stay away from from her spouse because of the employment reason. So then in that case, when the court asked for for restitution of conjugal right, she has explained that because it's a reasonable cause. Court has said that no, the restitution of conjugal rights has to be there. So similarly, there have been question raised on this conjugal right. So there are few case laws which you can remember. For example, one of the cases T. Saritha versus T. Venkateshwar, 1983. Here, there was a question raised that this section itself is against 21 because we have a right to life and liberty, and under that, this is a this section 9 is restricting that. So that is why it should be held void. While in the case, recent case 2019, Ojava Pathak versus Union of India. Here the court has said that uh, uh, whether this section is violating 14 and 21 or not, whether it is unequal burden given on women under this section or not. So this is also a case. Apart from this, there is one more case, Manju Lal Javeri Lal. So these are the cases under this. Apart from this, when we talk about the judicial separation, so this is done basically to bring reconciliation. So basically, if there is any kind of scope that the people will not get the divorce, so they give a last chance for the judicial separation. Under that, they have a there's a possibility that they will get back together. So it after the decree, the cohabitation is not obligatory, but after judicial separation, if one of the spouse dies, then the other spouse can inherit the property of the dead spouse, because it was judicial separation, the divorce did not take place yet. And then when we talk about divorce and its ground, have you covered that? The divorce and the theory of divorce. Section 13. From this question are asked a lot. This is an important topic. Thirteen one. The fault theory of divorce. Anyone has covered section 13 completely yet? Yes, I'm asking you all.
No, ma'am.
Anyone else?